Hello everyone. Today we will gain some basic knowledge about contract laws through some basic multiple choice questions. So without wasting any time, let's start with it. The first question is the agreements, the remaining of which is not certain or capable of being made certain under the section 29 is what? The options are A, void, B, voidable, C, illegal, or D, valid. The correct answer to this question is option A. That means to say, agreements which are not certain or not capable of being made under section 29 is void. The next question is A, B, and C are sureties for D. Then all enter into three several bonds, each in different penalty, namely A in the penalty of 10,000 rupees, B in that of 30,000 rupees, C in that of 50,000 rupees, conditioned for D's duly accounting to E. D makes a default to the extent of 30,000 rupees. A, B, C are liable to pay in what ratio? Options are A in the ratio of 1 is to 3 is to 5. B only B is liable. C each liable to pay 10,000 rupees. Or D only C is liable. The correct answer to this question is option C. That means to say if D makes a default to the extent of 30,000 rupees, the ratio of liabilities, that is, upon A, B, and C, will be that each person will be liable to pay a sum of rupees 10,000. The next question is A, B, and C are sureties to D for sum of rupees 30,000 rupees, which is lent to for E. E makes a default in payment. The A, B, C are liable in what ratio? Options are A to pay 1,000 each, B only B is liable, C only C is liable, or D only D will be liable. The correct answer to this question is option A. That means to say the ratio in which A, B, and C are liable will be that to pay 1,000 each. Next question is Section 133 of the Indian Contract Act 1872 provides for what? Options are A. Discharge of surety by variance in the terms of contract. B. Surety's liability. C. Release of one co-surety does not discharge others. Or D. Implied promise to indemnity surety. The correct answer to this question is option A. That means to say that the section 33 of 133 of the Indian Contract Act 1872 provides for the discharge of surety by variance in the terms of contract. The next question is in contract of guarantee, the person who gives the guarantee is known as dash. Options are A. Debtor, B. Surety, C. Creditor, or D. Principal debtor. The correct answer to this question is option B. That is, in a contract of guarantee, the person who gives the guarantee is known as surety. Question is Section 148 of the Indian Contract Act 1872 provides for what? Options are A. Bailment, bailer, and bailee defined. B. Bailee when not liable for loss, etc., for the things bailed. C. Bailer's duty to disclose faults in goods bailed. Or D. Effect of mixture without bailor's consent when the goods can be separated. The correct answer to this question is option A. That means to say section 148 of the Indian Contract Act provides for the definition of bailment, bailer, and bailee. The next question is if the bailee, with the consent of the bailor, mixes the goods of bailor with his own goods, the bailor and the bailee shall have an interest in production to their respective shares in the mixture thus produced. This situation or this condition is options are A. True, B. False, C. Partly false, or D. Not clear. The correct answer to this question is option A. That means to say this condition is true. The next question is a partnership deed contains the details associated with which of the following? Options are A. The nature of business and duration of firm. B. Capital contribution, profit loss sharing ration and other agreed terms. C. Name of firm and partners. Or D. All of these. The correct answer to this question is option D. That means to say a partnership deed contains the details of nature of business and duration of firm, capital contribution, that is profit and loss sharing ratio and other agreed terms, and the name of firm and partners associated with it. The next question is a partnership business is determined by mutual agreement of a partner. The kind of agreement can be options are A. Oral agreement, B. Written agreement, C. Oral or written agreement, or D. None of them. The correct answer to this question is option C. That means to say a partnership business is determined by the mutual agreement of partners. This agreement can be oral as well as a written agreement. The next question is the common terms of partnership written agreement is known as which of the following? Options are A. Agreement, B. Partnership deed, C. Partnership contract, or D. Partnership act. The correct answer to this question is option B. That means to say a common term of partnership written agreement is known as partnership deed. The next question is when no agreement exists between the partners, what will be the benefit sharing ratio between them? Options are A. Unequal, B. Equal, C. It will depend on the experience of a partner, or D. It will depend on the partner's capital. The correct answer to this question is option B. That is where there is no agreement or no terms that determine the profit sharing ratio, the profit will be shared equally between the partners. The next question is which of the following options is not a feature of partnership business? Options are A. Mutual agency, B. Limited liability, C. Limited life, or D. Ease of formation. The correct answer to this question is option B. That is limited liability is not a feature of partnership business. Next question is in which type of partnership there is no partnership duration mentioned? Options are A. Partnership at will, B. General partnership, C. Registered partnership, or D. Limited partnership. The correct answer to this question is option A. That is, in partnership at will, there is no partnership duration mentioned in the agreement. The next question is a partnership business regarded as a separate legal entity? Options are A. Yes, B. No. The correct answer to this question is option B. That is, no. A partnership business is not regarded as a separate legal entity. The next question is which of the following strikes only a document and not transaction? Options are A. The Transfer of Property Act 1882, B. The Registration Act 1908, C. Both A and B, or D. None of these. The correct answer to this question is option B. That means the Registration Act 1908 strikes only a document and not at any transaction.